Coons.
Thank you very much, Chairman Grassley. Let me open by just thanking you, Mr. Rodriguez, for the witness of your work in the Dominican Republic and Bolivia. I think IGM does excellent work, and I wish we had the opportunity to explore it at more length, the important work against human trafficking, both here in the United States and in the hemisphere. But I just wanted to open by commenting on my gratitude for your work, and that I think it teaches about our values and priorities when people go to difficult places and do hard work on behalf of freedom. So thank you for what you do.
Thank you, Senator.
My questions will mostly focus on intellectual property and Mr. Iancu. If I might welcome, in both your cases, your introductions and your stories remind us of some of the greatest qualities of the American people. Mr. Iancu, if I might go right into some issues that I think will face you at the Patent and Trademark Office, the post-patent grant review process that was implemented post-AIA. It's been criticized for being unfair to patent owners for a number of different reasons. The use of a claim construction standard that's different from that used by district courts, the lower burden of proof in order to prove invalidity, the inability of patent owners to amend, the lack of a standing requirement, concerns about serial petitions, and the high rates of both institution and invalidation. I'd be interested in whether you share any of those concerns and what, if any, actions you might take if confirmed as director to address some of those concerns.
Senator Coons, as you have identified, we have experience now with the post-grant system for the past 5 or so years, and I am very much aware of, shall we say, strident criticisms of some of the proceedings.
Strident and well-founded, or strident and baseless?
Well, you know, in some instances, well-founded, but I think we have to be careful because the system needs to be very well balanced. And folks do mention statistics a lot, and we all know what they say about statistics. We have to be careful with them. But it is a true fact that, the system is criticized heavily, and that is important to note. Because if the inventing community does not have confidence in the IP system, then investments do not get made, and inventions slow down, and the economy doesn't benefit. I think, if confirmed, Senator, I very much look forward to looking at the history that we have. Working with you and other members of Congress who are interested, and senior leadership at the office, as well as members of the stakeholder community, and drill down and identify what is reality and how we can improve.
Thank you, Mr. Iancu. I have 2 more questions, if I might, Mr. Chairman. I'm troubled by recent Supreme Court jurisprudence on what is patentable on eligible subject matter, which I think calls into question whether patents should be issued at all in some areas where there's, I think, great promise in the innovation economy, in particular medical diagnostics and computer-implemented inventions. And this wandering jurisprudence has created a great deal of uncertainty, with patentability decisions relying more heavily on the luck of the draw, of who the examiner is, who the judge is, Federal Circuit panel. In your opinion, is the current Supreme Court jurisprudence good for American innovation? And what, if anything, could the office do to address this situation?
Current Supreme Court jurisdiction on Section 101 is the current law of the land, and this is what the office follows and what the courts follow. It has, in the areas that you have mentioned, Senator, introduced a level of uncertainty. And in the grand scheme of things, that jurisprudence is fairly recent. The lower courts are still working through drawing the appropriate lines. It is important to see how that develops. At the same time, the office, although it has already issued guidance on Section 101, the office perhaps can do more. And if confirmed, I will make one of my priorities to work with the office and focus on Section 101 and see what further guidance can be issued.
My last question, thank you, Mr. Iancu. Along with Chairman Grassley, we wrote a letter to Commerce Secretary Ross in July asking for information about the Patent and Trademark Office's participation in the Department of Commerce's Shared Services Initiative. We only received an answer yesterday, nearly 5 months later. And I think it's unacceptable it took so long to get an answer that could have been provided promptly, and where, frankly, a lot of it was just simple facts. The letter of response provided no answer about whether the USPTO would be required to continue to contribute to Commerce's shared services, even if it won't use them. As you know, patent fees paid for by users is what funds the Patent and Trademark Office. And this is, I think, a serious potential misuse. So I'd be interested in whether this also leads you to have concerns that might undermine the director's independence, which is established by statute. So if confirmed, Mr. Iancu, would you commit to investigating and providing full concrete answers to the questions posed in the original letter within your first month, and commit to informing the committee if political pressure is applied to have you agree to divert USPTO fees away from the mission of the agency?
I do commit, Senator, in, if confirmed, to investigate. Happened yet. On the broader question of fee diversion, I also agree it is really important to fully fund the office. The office is fully funded by user fees. Those fees should be used to, for the activities of the office for the benefit of those users.
Thank you, Mr. Iancu, and thank you for being a great partner, Chairman Grassley, in seeking answers to a wide range of questions over a number of topics over many years. Thank you to the panel, and congratulations on your nomination.